It's my distinct pleasure to introduce this evening's guest, Martha S. Jones. Martha Jones is the Society of Black Alumni Presidential Professor, Professor of History, and a professor at the SNF Agora Institute at the Johns Hopkins University. She is a legal and cultural historian whose work examines how Black Americans have shaped the story of American democracy. Professor Jones is the author of Vanguard: How Black Women Broke Barriers, Won the Vote, and Insisted on Equality for All in 2020. Selected as one of Time's 100 must-read books for 2020. Her 2018 book, Birthright Citizens, A History of Race and Rights in Antebellum America, published in 2018, was the winner of the Organization of American Historians Liberty Legacy Award, Best Book in Civil Rights History, the American Historical Association's Littleton Griswold Prize for the Best Book in American Legal History, the American Society for Legal History John Philip Reed Book Award for the Best Book in Anglo-American Legal History, and that's not all, and the Baltimore City Historical Society Scholars Honor for 2020. Professor Jones is also author of All Bound Up Together, The Woman Question in African American Public Culture, 1830 to 1900, and a co-editor of Toward an Intellectual History of Black Women, UNC Press, 2015, together with many articles and essays. Professor Jones is a public historian, writing for broader audiences at the New York Times, the Washington Post, the Atlantic, USA Today, Public Books, Talking Points Memo, Politico, the Chronicle of Higher Education, and Time. She's also an exhibition curator for Reframing the Color Line and Proclaiming Emancipation at the William L. Clements Library, and an expert consultant for museum, film, and video productions with the Smithsonian's National Portrait Gallery, the Charles Wright Museum of African American History, PBS's American Experience, the Southern Poverty Law Center, Netflix, and Arte. Professor Jones holds a Ph.D. in history from Columbia University and a J.D. from the City University of New York School of Law, which bestowed upon her the degree of Doctor of Laws honoris causa in 2019. Prior to her academic career, she was a public interest litigator in New York City, recognized for her work as a Charles H. Revson Fellow on the future of the City of New York at Columbia University. Professor Jones is an immediate past president of the Berkshire Conference of Women Historians, and today serves on the boards of the Society of American Historians, the National Women's History Museum, the U.S. Capitol Historical Society, the Johns Hopkins University Press, the Journal of American History, and Slavery and Abolition. For our program this evening, Professor Jones will begin by providing an overview of the inception and the contours of her prize-winning 2018 book, Birthright Citizens, A History of Race and Rights in Antebellum America. We'll follow that presentation with a series of questions intended to help us probe more deeply into the topic of the struggle for citizenship in America by Black Baltimoreans in roughly the first half of the 19th century. And I will also attempt to draw into the conversation aspects of that struggle for citizenship that draw more directly on people and events in Pennsylvania and Lancaster County's history. Finally, we encourage you, our audience, to post questions to the Q&A function, usually at the bottom of your screen. Those questions will be gathered, relayed to me, and we'll make every effort to get to as many of them as time permits. And with that, again, it is my pleasure to give you Professor Martha Jones.
Good evening, and thank you very much to you, Tom Ryan, and to everybody there at Lancaster History for welcoming me, for going the extra mile to bring us together virtually. It's really an honor to be here. Um, I thought I'd take a few minutes at the outset just to, in a sense, tell the story of this book. I know we'll have a chance to drill into many of the particulars, but I thought I'd start by a kind of origin story. Where does this book come from for me? And one answer is maybe not one you'd expect, but it came out of a kind of, I'll call it frustration. Um, I spend a lot of time at academic conferences, meetings, workshops, and uh, very often I would hear papers that centered on an important and even notorious US Supreme Court decision, Dred Scott versus Sanford. Um, Folks may have heard of Dred Scott, but among other things, Dred Scott is an 1857 Supreme Court decision in which Justice Roger Brooke Taney concludes that no Black American can be a citizen of the United States, be they enslaved or free. So this is a case and a subject that has been subject to really far-ranging, if not exhaustive, scholarly treatment. But I was someone who really thought, or at least wondered, wasn't there more to the story of Dred Scott than the case itself? So my way of probing that curiosity was to come to the archives of Justice Taney's home city, which was Baltimore in Maryland, to ask what was going on closer to the ground in a city like Baltimore that may have fueled Justice Taney's thinking about Black citizenship, may have, in fact, led to his deep thinking on the subject, but also his deep worries about the prospect of Black citizenship in the United States. So I come to this book trying to think about the Dred Scott case, but really to think beyond the Dred Scott case and to construct a new kind of archive that is hardly limited to Justice Taney's decision in Dred Scott, and really through local courthouse materials lets us explore the lives of the free Black Americans in Baltimore, who were very much, it turns out, informing Justice Taney's thinking and fueling his concerns about the future of the United States as a white man's nation. So there's the scholarly interest. But as Tom Ryan mentioned before I began my academic work, I had been a lawyer, a public interest litigator in New York City. And one of the more commonsensical things I had learned out of that work was that a great deal of the action in law happens not at high courts, not before the US Supreme Court. It happens instead in the local courthouse. And while it might elude headlines and it might elude casebooks, my years in local courthouses in New York City let me know that there was likely a story to tell from that vantage point. So once again, I show up in the wonderful Maryland State Archives and spend many, many years moving through docket books and case records and the like in an effort to piece together from the perspective of Black Americans and from the perspective of the everyday workings of a courthouse, what questions about citizenship looked like in the years around the Dred Scott case. I learned a lot of things, but I think three of them stand out and have stood the test of time. The first is that there really is a major story about US citizenship well before we get to the moment in the post-Civil War era, when Congress, in the wake of the Civil War and slavery's abolition, will turn to the question directly of African American citizenship and provide for, in 1868, in the text of the 14th Amendment, birthright citizenship. For a long time, that moment was where historians began their telling of the story of American citizenship, because we knew that the founding documents, like the Constitution, had been silent about citizenship. And historians had, in a sense, misunderstood because they hadn't quite probed Black Americans' perspectives, had misunderstood citizenship to have been much of a non-question before the Civil War. Well, it turns out when we take the perspective of Black Americans, we see citizenship emerge importantly as a central question, not only for them, but for the lawmakers with whom they are interacting with. The second insight is really about the way in which those lawmakers fail. They fail to achieve the kind of fundamental purpose of law, which is to offer predictability and finality to questions like, am I a citizen or am I not a citizen? And so Birthright Citizens is a story of lawmakers in courthouses, in high courts, in state legislatures, in Congress, who from the 1820s forward approach this question of Black citizenship again and again, urged on by the pressing claims of Black Americans, and still they fail, they fumble, they punt the question. And so it is also a story about how lawmakers in the United States in this period really left Black Americans in a profoundly unsettling legal limbo. Without any clarity, without any certitude, without any final sense of where they stood before the Constitution. Black Americans in this period face the threat of colonization, that is removal from the United States as non-citizens. And so this question is a burning one, but it's one in a sense that's too hot for lawmakers, with the exception of someone like Roger Taney, to attempt to settle. The last one is about the broad story of American citizenship and national belonging. And what Birthright Citizens demonstrates is the essential critical degree to which Black Americans craft the legal theory, promote and urge a view of American citizenship that is the fundamental citizenship regime by which we live even today, birthright. And so we have, in a sense, Black Americans who bequeath to generations of the despised long after their citizenship is settled. For Chinese immigrants and their children, for the children of communist dissidents, in the 21st century, the children of Muslim immigrants to the United States. Black Americans bequeath a principle, see it through to instantiation in the Constitution, and they are thinking their concerns, their essential necessity for the protections of citizenship continue to protect millions upon millions of Americans even today. There is, I guess I'll call it an afterlife to this book, and it's one that I didn't anticipate. But this was a book, as Tom Ryan mentioned, that was published in 2018 with important but rather modest objectives. That is to say, it was a book that was written by and large to shape scholarly thinking about the history of law and citizenship and the Constitution. But when it was published in 2018, it met up with some very public and some very highly placed threats that birthright citizenship was an illegitimate and ill-considered doctrine, that birthright should in fact be ended. And while those threats came from high places, they never came with a lot of particulars. But there's no question but that many people in the United States and really across the globe came to a new interest in understanding the principle of birthright and understanding where it had come from. And so this story, which is centered on Black Americans in the early decades of the 19th century, has turned out to have important lessons, important insights for all Americans in the 21st century. No one more so, I dare say, than immigrant Americans and their families who have, and to an important degree, continue to live, not unlike Black Americans lived in the 19th century, under the specter of uncertainty, under the specter of unsettledness, under the specter of the threat of removal from the United States. So in the months and years after the publication of this book, I have spoken to many kinds of audiences, but perhaps none more so attentive, none more so with the stakes in this history than immigrant Americans in the 21st century. So I think if it's all right with you, Tom, I'll leave it there. And thank you again for spending the evening with me. And I look forward to our conversation.
Great. So it strikes me as just a fascinating, almost historical accident. I don't know if that's the right term, that that now contemporary people facing some of the same questions of citizenship have a tremendous debt of gratitude to African American Baltimoreans who performed, as I think you discuss it in your book, in the court system to state claims that that were foggy at best. Mm-hmm. You mentioned that the U.S. Constitution doesn't really directly address the question of citizenship, except perhaps in one small little instance that relates to the presidency. Do you see that as having ultimately been a disadvantage, or is it possible that it worked to the advantage of those in Baltimore in the 19th century who were jockeying for position and trying to find wiggle room, and it appears that there was plenty of wiggle room there?
Yeah, hardly by design. It is true that Black Americans seize on the ambiguities of the Constitution. They understand certainly that late 18th century framers of the Constitution, many of them slaveholders, others of them who held anti-Black racist views, may not have intended them to be full citizens equal to property holding white men at the end of the 18th century. But nobody says that in the Constitution exactly, right? And instead, there is this curious provision that you alluded to that says that the president must be a natural born citizen of the United States. And so the folks I write about say two things, right? One, there is no color line in the Constitution. The Constitution does distinguish between enslaved and free people, for example, but it does not distinguish between Black and white people. And that if the president is a natural born citizen of the United States, there must be such a category, right? There must be such a creature. And are we not also natural born citizens? And once they light on this theory and begin to develop it, they're now going to find themselves in confrontation with lots of folks who are not of one mind. And you're right to say that in some moments that might work to an advantage because it forestalls the most draconian of remedies, which would be the wholesale removal of Black Americans from the United States. Lawmakers are really not of one mind about that. But on the other hand, I think that we can't discount the extraordinary burden of what it means to live, to build families, communities, institutions in a nation that includes those highly placed folks like Justice Tawney, who would open the door and constitutionally sanction your forced removal from the country. So I would say, in a sense, we are as a collective profoundly fortunate, right, that Black Americans seize on this question and think hard about the relationship between citizenship and democracy, and teach the country and force this lesson. But it's not an enviable place to sit in early America, I think it's fair to say.
Yeah. So I'd like to kind of get back to Chief Justice Tawney for a minute and kind of approach him through the gaze of James Buchanan. Americans place typically a lot of emphasis on the rulings of the Supreme Court. And we hear about that a lot these days. And there's a lot of contention about who gets appointed to the court and what it might mean in the day-to-day life of many Americans. At Lancaster History, we embrace the task of interpreting the legacy of our nation's 15th president, James Buchanan. After an illustrious career in law, in Congress, and international diplomacy, Buchanan's term as president caused much of that luster to tarnish, to put it mildly. One episode in particular, though, I think does stand out, and it's relevant to this conversation of citizenship, and that's the Dred Scott case with Tawney as Chief Justice. And Buchanan meddles where he should not have. Can you say a little bit more about the impact of not necessarily that meddling, although I'd be interested to hear anything related to that, but really more the impact of the Dred Scott case on this struggle for citizenship among Black Americans?
Yeah, thank you for that. I mean, part of what President Buchanan's meddling, and Buchanan is hardly the only, right, highly placed political leader in the United States who is fixated on the prospect of a decision in the Dred Scott case. The stakes in the case include not only Black citizenship, right, but the expansion of slavery in the territories, and in fact, the legitimacy of slavery, right, in the territories. And so there are many folks who are fixed on this decision. But here, my focus is on the citizenship question, and that turns out to be, when we look closely, an important lesson in fact, the limited power of the US Supreme Court. Perhaps some folks will know from the study of a very different moment, the moment of Brown versus Board of Education, how preoccupied the Brown court is in the unanimity of its decision and its weak capacity to enforce it. That is no less true in the era of Dred Scott. And while we oftentimes invoke the powerful but terrible rhetoric of Justice Tawney's decision, in that case, we overlook Justices McLean and Curtis, who dissent strongly in Dred Scott and make the full-throated case for Black citizenship in the face of Tawney's decision. There is a strong disagreement amongst Supreme Court justices, not on fine points, right, but on the major question: are Black Americans citizens? And McLean and Curtis say yes, they are. What does that mean? It means that there is dissension among the Supreme Court justices, and then there is dissension in the lower federal courts in the wake of the decision. And I could find only one lower federal court that in the state of Mississippi that ultimately enforces the doctrine of Dred Scott and regards a free Black person as a non-citizen. In all other cases, whether it comes up in federal courts or in state courts, judges find a way around and do a workaround and narrow the decision and its reasoning such that they continue to regard Black Americans as citizens despite Justice Taney's ruling. And Taney knows this. And in his personal correspondence, we find evidence of his disappointment and his frustration. And he's so frustrated at the unwillingness of lower courts to defer to his decision that he pens what's come to be known as the supplemental or the secret opinion. He drafts a second Dred Scott opinion, hoping that he will get another case along the same lines and that he will have the chance to, in essence, re-argue his conclusions and perhaps persuade. So while Dred Scott is a devastating decision for the principles that it enunciates, it's devastating because indeed it does come from the highest court in the United States. It has much less effect on the ground than I think we had once assumed. And for Justice Taney, in my view, Dred Scott is a profound disappointment and even a failure, one that he laments for the balance of his life.
So I want to shift a little bit. Thank you for that. I think it was commonplace, and maybe still is in some circles, to assume that enslaved people in America in the 18th and 19th centuries kind of existed outside of legal structures. And perhaps that assumption extended to free Blacks as well. And yet it sounds as if smaller local courts, and this is kind of to the point you're just making, and not so much the high courts, really provided this stage where Black Baltimoreans could more readily assert their claims to a place in the pecking order, to a place with some status within the system. So my question is, how long do you think it took before there was an accumulation of cases and appearances in these courts before the net effect was to begin to shift the balance toward this kind of accumulation of citizenship rights cases? Or was it obvious from the very earliest cases that this is going to work? We've got a pathway here. Now we just have to keep working it. That's the first part of the question. The second part is, who assisted them in these challenges? What kind of legal representation? It'd be fascinating to know the genealogy of those attorneys who were there assisting these cases and who trained them and where they came from, that sort of thing.
Yeah, thanks for that. You know, on the one hand, we could answer that question by looking at a very special category of cases, and those are freedom suits. And then we recognize that enslaved people said to be enslaved as litigants has an old and long history in American courts, even in colonial American courts. And so Black Americans are not strangers to the legal system at all. But in Baltimore, and part of the reason I set this study in Baltimore is that in the antebellum years, Baltimore is, first of all, emerging as the third largest city in the United States. Its courthouse is not one of little consequence. It is a major site for all kinds of litigation. Secondly, Baltimore is increasingly a free city, which is to say that slavery is waning in its demographics, but in its significance as a labor institution in a city like Baltimore as we move toward the Civil War. And by 1860, Baltimore will have the largest community, more than 25,000 free Black Americans, and only 2,500 enslaved people in the city. So we're seeing in real time the ways in which the emergence of now a formally enslaved community is making its presence felt in a local courthouse like that in Baltimore. This is a story that historian Laura Edwards has told in her wonderful book, The People and Their Peace. In the rural Carolinas, Melvin Ely has told this story in Virginia, that when we go to the local courthouse records, remarkably, we find Black Americans as claimants, as litigants, as parties, and more. So in Baltimore, your question was sort of, how does this gain a kind of traction? And while it's in one sense hard to say, we have to imagine a little bit how Black Americans themselves are developing their own legal acumen, legal consciousness. And we can see some of that as we, for example, in this book, I follow the workings of African-American churches, their incorporation, and then the litigation that emerges around everything from leadership and control of the money to mortgages and the safeguarding of property. We can see the processes by which collectively Black Americans are developing legal savvy increasingly in the antebellum years. And at the same time, you're right to point out that this is a book that I was very interested in the lawyers. Maybe that's a little self-serving, but I had the same question you did, because some of the questions and some of the issues, some of the litigation is complex, and certainly benefited in various ways from legal expertise. There's no shortage of lawyers in Baltimore, and that's important for appreciating that lawyers make themselves available to Black Americans for a fee. And we find them hiring or attempting to hire some pretty distinguished figures, including William Wirt, who had one time been the Attorney General of the United States, but also a Baltimorean who does business with free Black Americans when they're looking for a legal opinion, or John Latrobe, who will emerge later as president of the American Colonization Society as a young lawyer, is representing free Black Americans for a fee as he would represent anyone. So these aren't folks who are nascent abolitionists or, undercover radical Republicans in the making at all. But this is a city and a legal community that to an important degree wants to establish and shore up the courthouse as a major arbiter of everything in the city of Baltimore, including the lives and the prospects of free Black Americans. And so I'm able to find some regulars like the Horowitz brothers, who represent Black Americans, yes, in Baltimore, but also in Philadelphia, in all kinds of proceedings, including these sort of rights-based questions, but also in estate proceedings and the like. And they are an important part of the story because these are not men who have a political position on the question of citizenship, but are building practices, and Black Americans are prepared to pay the fees.
Thank you. Today we often think of the courts as a place where you only end up when something goes wrong. So we try to avoid ending up in court. But your work suggests, while there is some of that, some of these things being tried are coming out of challenging situations, like you referred to the churches African-American churches, and whether it is a legal dispute over property or whether it is the allegation of a misuse of funds. Those are things that end up in court. But you also have instances that it's applying for what is it, a gun license or a permit for a gun. So they're kind of the normal things that people would go to the courts to do. And your work kind of explicates how they see that as an opportunity and kind of seize upon it. And so my question is, did they take that path because the courts were really the last resort, or maybe their only avenue to assert these claims of citizenship? And are there other examples that might be contemporary where other groups of people are using the courts to assert rights because it's either one of the only options they have or it's a convenient option?
Yeah. I think one way to think about your question, is to compare Black Baltimoreans to their peers in a city like Philadelphia or Boston, right? Where Black Americans are, slavery has been abolished by this period in those states. Black Americans are assumed to be citizens, even as they may be subject to a kind of second-class citizenship. And so in cities like Boston and Philadelphia, Black Americans, New York, Black Americans are making full-throated claims for what we would think of as civil rights. And that is not the position, right, that Black Baltimoreans occupy. Maryland continues to be a slaveholding state. The colonization regime is very present and very threatening. And frankly, to openly ally oneself with the abolitionist position, right, which is the position of not only slavery's abolition, but civil rights, is deemed seditious in the state of Maryland. It's not an open position that Black Americans can full-throatedly advocate for. But I understand, and I think we come to understand in this book the ways in which to, for example, secure a permit for a gun, a license for a gun, a permit to travel, go to what many Americans, Black and white, understand to be increasingly, right, the fundamental markers of what it means to be a citizen. And I'm able to follow some of the characters in this story into the years just after the Civil War ends, to see what they do next. And now, men who had modestly gone to the local courthouse every year to get that gun license, now they are members of a militia, right? And they are occupying the streets of Baltimore, embodying citizenship in a much more full-throated way than they ever could have in the years before the war. So it was important for me, as best I could, to sort of trace that story and to see how what it means to possess a gun, how it changes, or how the manifestation of that changes with the abolition of slavery and the advent of Black citizenship. The other thing I'll mention is that there are many sorts of folks in this courthouse. Black Americans are hardly the only litigants, but interestingly for your question, I think there are immigrant Americans, tens of thousands of them in a city like Baltimore by the 1840s and 1850s. Among them, men who want to become not only citizens, but more to the point, they want to be voters on election day. And what we learn is that alongside Black Americans who are coming in to secure permits to travel or licenses for guns are immigrant men who are standing up before the same judges in the same afternoon sometimes to renounce their allegiances, which is the first step to naturalization, and they do so that they can vote. And for me, discovering that juxtaposition about what is possible in a limited sense for Black Americans in that scene, and what is possible for white immigrants, I think are part of a whole story about how men are making claims to their standing before the court in ways that cannot be the same, right? Structurally, they cannot make the same sorts of claims, but I think they resonate importantly with one another.
Absolutely, yeah. Um, so I want to switch to another famous Lancastrian. In addition to Mr. Buchanan, we have Mr. Thaddeus Stevens, who, aside from being Buchanan's political nemesis, had some fairly strong opinions about citizenship, and in particular, citizenship for African Americans. In your Baltimore work, we've already referred to these gun licenses that Blacks would apply for. And here we have William Parker, a free Black man living in Christiana, Pennsylvania, a gun-owning Black man in Lancaster County, who stood at the center of a major controversy where, as we all know, Edward Gorsuch and his son and a few others come to reclaim what they see as their property. And one in which Mr. Stevens then assists in the defense, now in a federal court. What implications do you see in either the resistance itself or in the court case that kind of ties to this question of citizenship?
Yeah. Well, in part, the story of Christiana is another piece of appreciating, right, the significance of that gun license and that possession of a gun, that open and notorious possession of a gun. And it is self-defense. And there's no question that for Parker and his comrades resonates importantly in Baltimore. But in my story, it's important to remind folks, right, that Gorsuch and his posse come from Baltimore.
Right.
And that this is a story that very much is generated out of not only the proximity, right, of Baltimore to Pennsylvania, but also the routes, right? The routes that are typically being traveled by many Black Baltimoreans, including those who are fugitives. For me, this story turned out to be more fascinating than I could have imagined when I realized that the governor of Georgia, of Maryland, takes a personal interest, right? It sees in the trial then in Pennsylvania, sees consequences for how slavery fugitives and more will be understood in Maryland in the wake of this trial. And it is the reporting of those who sit through the trial in Pennsylvania that really sheds a light on how provocative a scene that trial is. The fact that there is a trial, right? That there is full due process. Not only due process, there is dignity and equal regard extended to Black defendants in this courtroom. This is the specter, right, of what Baltimore and Maryland fear most, right? That free Black Americans will be so empowered that they would be able not only to get those licenses or those permits, right, but to fully defend themselves, right, in a system that would extend to them the rights of citizens when it comes to criminal charges. And this is the this is the upturning of a social order that Baltimoreans fear, and it's happening, just up the way in Pennsylvania. And those recountings, I think, are very telling for how Baltimoreans are thinking about the same sorts of characters in their own city.
Yeah. Great. Well, I'm going to pose one more question, but I want to remind our audience that you can pose your own questions in the Q&A function at the bottom of the screen. And I've got a couple here in front of me that we'll get to in a minute. But please come forward with other questions that you might have. I want to ask you about abolitionists. And, we know that here in Lancaster County, there was a tremendous amount of Underground Railroad activity. There were abolitionists, some of them of a Quaker persuasion, but not exclusively, who were publishing in local newspapers that they would not abide by the Fugitive Slave Act, that they would not conform to being deputized to assist, et cetera. So we often think of abolitionists as these wonderful folks who are standing against slavery and standing alongside those who are willing to risk their lives for their own freedom. And yet there's an underbelly to some of the abolitionist story, and it has to do with the colonization movement. That you have this kind of push and pull, that some of the abolitionists were really instrumental in the colonization movement, which is really more about expelling Blacks from the United States. So what is this intersection between abolition and of slavery and attempts to remove Blacks from the United States through this colonization movement?
Yeah. So colonization is an old idea, right? An 18th century idea that gets new traction in the 18 teens. And it knits together Northerners and Southerners, Democrats and Whigs, Republicans later. It even knits together slaveholders and non-slaveholders through a commitment to a future for the United States as a white man's country. Mm-hmm. What does that mean? It means that colonizationists commit to, while they don't all agree about the end of slavery at all, what they do agree upon is that as slavery ends, should slavery ends, when slavery ends, it is necessary to remove free African Americans from the United States. And there is no state more firmly and enduringly committed to colonization than the state of Maryland. Maryland has its own very active, very influential state colonization society. It's one of the few societies that wins an annual allocation from the state legislature. It establishes its own separate colony, Maryland in Liberia, to which it proposes to remove free Black Americans. And this is an extraordinary pressure on the folks who are at the center of my story in Birthright Citizens. They understand that they need to defend themselves against the prospect of colonization, which largely is a movement that relies upon, strong arm persuasion, but in Maryland includes advocates who would make it obligatory by state law to remove Black Americans from the state without cause and without consent. The folks in my book turn to citizenship because they believe it is or may function as a bulwark against removal by colonizationists from the state and from the country. So citizenship, yes, has lots of symbolic and aspirational facets to it. But for Black Baltimoreans, citizenship, they hope, will be that status that will, for example, exempt them from the fates of, say, the Cherokee in Georgia, which they study and understand very clearly as unsettlingly akin, right, to the removal proposals that colonizationists work through. It is for me, or it was for me, a really a new appreciation for the ways in which the endurance of anti-Black racism in the post-Civil War period is, yes, a legacy of slavery, but is very much a legacy of colonization, and that commitment that even in the wake of slavery's abolition, Black Americans are not. It's how I see Dred Scott. Really, Taney is a colonizationist, and his attempt to defeat Black citizenship is an effort to keep the door open for colonizationists who might move to remove Black Americans from Maryland and Missouri and more.
So we've got a follow-up from one of our audience members to this question about colonization. And I hope I get it right here. What, in your view, led to the apparently swift decline in support by national politicians for colonization between 1862, when Lincoln advocated it at length in his annual message to Congress, and 64, when the subject was apparently not addressed at all in the Union, not Republican, party platform?
Yeah, I think there are a couple of things to point to importantly. One is an 1862 decision from then Lincoln's Attorney General, Edward Bates. Bates has asked the question that attorneys general have been asked for decades before: are Black Americans citizens of the United States? Up until 1862, and Bates, the answer had always been sometimes equivocal, but usually leaning strongly toward no. And Taney had been among the attorneys general who had been asked and answered that question during his tenure as Attorney General. Bates sits down to pen what, in essence, is a treatise on the question of Black citizenship, and he adopts the reasoning that Black Americans have been promoting for a decade. He adopts the reasoning of Justices Curtis and McLean in the Dred Scott dissents, and makes the full-throated case that Black Americans are citizens of the United States. And so now we have the tables beginning to turn on this fundamental question that I think is one factor for us to keep in mind. And then I think with respect to Lincoln, and there are much better Lincoln scholars in the room, at least figuratively, than I, but as I understand it in part, right, the evolution of Lincoln's thinking is in part a function of his relatively recent but powerful engagements with free Black leaders, right, who represent for themselves to Lincoln not only their visions of who they are, but their literal capacities, right? And this is new for Lincoln, who has long been a colonizationist, and as I'm sure the questioner knows, really will only abandon colonization on the eve of his issuance of the Emancipation Proclamation at the end of 1862. Colonization doesn't wholly go away, even through the war and those changes. The society itself will persist. But Black Americans, after 1866 and the Civil Rights Act of that year and the 14th Amendment, now believe themselves to have a sure instrument to resist the kind of compulsion that undergirded colonization for a very long time.
Okay, thank you. I'm going to try and get a couple more questions in
Yeah.
here in the few minutes we have left. here is a name that I'm not familiar with. Does Curtis Jacobs' position that even a freed slave wasn't really free, but a ward of the government, gain a foothold in other states? A legitimization of taking free blacks into slavery?
Yes, and in fact, Jacobs is defeated, right, by organized free African Americans from Baltimore who head to Annapolis, circulate and a petition and collect signatures and engage in a confrontation with Jacobs personally, but with lawmakers in Annapolis more generally, and Jacobs's proposals are defeated, but they succeed. Similar kinds of proposals succeed in the state of Virginia, where compulsory re-enslavement, mandatory exile become the law very late, right, in the 1850s. But Jacobs's proposals are part of a wave, right, of new draconian so-called Black laws that are to an important degree generated out of John Brown's raid at Harper's Ferry.
And then one final question here, and this is from Gail. Tawney, though abhorring slavery, apparently he considered it a blot on our national character, who freed enslaved people that he inherited, although he wanted to allow the decision regarding slavery to be left to states where it occurred, yet citizenship is a federal issue. How do we reconcile the public and private positions he holds? Is that clear?
Yeah, sure. There are historians like Tim Hubner who have explained Tawney's life as a life of declension. I have a different view. I don't think Tawney was ever anti-slavery in any shared way we understand that term. Just as Tawney doesn't free his slaves, he transforms the enslaved people in his household into, and in his possession, into what in Maryland are called term slaves. They now become bound laborers who continue to be his property for a very long time, and from whose labor he continues to benefit from a very long time. Justice Tawney was never an abolitionist as we understand that in the sort of Garrisonian radical abolitionist sense. He was at best, and you might say at worst, a colonizationist, but not someone who, in my view, not someone who whose views change very much over time. Justice Tawney is the same, has the same views about Black citizenship, for example, in the 1820s as he does in the 1850s.
Well, thank you for setting the record straight on that and sharing your insight on that. It has been an absolute pleasure, Professor Jones, to have you with us tonight and to field these questions and kind of share with us the tremendous insight and contribution that your book is to our understanding of citizenship, to our understanding of the Black struggle in America in the early and mid-19th century, not just in Baltimore, but I think it's emblematic of much of the country. So thank you so much. I want to thank our audience for your participation tonight, and remind you that there will be a pop-up on your screen with a survey afterwards. If you could take a couple minutes and answer those questions, it will help make sure that we are serving your interests and bringing you the kind of lectures and evenings that you'd like us to bring. So again, thank you, Professor Jones. It's been a pleasure.